discussed the above issues in following segments. 1. When the recruitment process commences and comes to an end, the basis of the doctrine that rules of the game must not be changed during the course of the game or after the game is played. Then whether the decision in game Manjusri is at variance with earlier precedents on the subject. Whether the above doctrine applies with equal strictness to a method or procedure for selection as it does to our eligibility criteria. Whether procedure for selection stipulated by act or rules framed either under the proviso to Article 309 of the Constitution or a statute could be given a go by. And whether appointment could be denied by change in the eligibility criteria after the game is played. As far as the basis of the doctrine is concerned, we relied on our earlier judgment in Sivan and CT. So far as the correctness of Manjusri is concerned, we examined the facts of that case as also the case of Subhash Chandra Marwa, and we held. 3. On the other hand, in K. Manjusri, the eligibility criteria for placement in the select list was challenged after interviews were held which had a material bearing on the select list. Thus, Subhash Chandra Marwa dealt with the right to be appointed from the select list, whereas K. Manjusri dealt with the right to be placed in the select list. The two cases, therefore, deal with altogether different issues. For the following reasons, in our view, K. Manjusri could not have been doubted for having failed to consider K. Subhash Chandra Marwa. Thus, further, what is clear from the above is that the object of any process of selection for entry into public service is to ensure that a person most suitable for the post is selected. What is suitable for one post may not be for the other. Thus, a degree of discretion is necessary to be left to the employer to devise its method to select the candidate most suitable for the post, albeit subject to the overarching principles enshrined in Articles 14 and 16 of the Constitution, as also the rules/statute governing service and reservation. Thus, in our view, the appointing authority/recruiting authority/competent authority, in absence of rules to the contrary, can devise a procedure for selection of a candidate suitable to the post, and by doing so, it may also set benchmarks for different stages of the recruitment process, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extant rules or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such benchmarks may be set any time before that stage is reached, so that neither the candidate nor the evaluator/examiner/interview is taken by surprise. The decision in K. Manjusri does not prescribe setting of benchmarks for various stages of the recruitment process, but mandates that it should not be set after the stage is over. In other words, after the game has already been played. This view is in consonance with the rule against arbitrariness enshrined in Article 14 of the Constitution and meets the legitimate expectation of the candidates, as also the requirement of transparency in recruitment to public services, and thereby obviates malpractices in preparation of select list. Then we examined whether it applies with equal strictness to steps for selection, and we cited few instances such as shortlisting and other evaluation instances. And then we considered whether the rule can be given a go by. And in this, we relied upon the judgment in Sivanandan CT, as also which was followed by a 3-judge bench in Salam Samarjit Singh. And finally, we considered whether appointment may be denied even after placement in the select list, where we relied on Shankarasan Das. So the final conclusions are as follows. Recruitment process commences from the issuance of the advertisement calling for applications and ends with filling up of vacancies. Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be changed midway through the recruitment process unless the extant rules so permit, or the advertisement which is not contrary to the extant rules so permit. If such change is permissible under the extant rules or the advertisement, the change would have to meet the requirement of Article 14 of the Constitution and satisfy the test of non-arbitrariness. The decision in K. Manjusri lays down good law and is not in conflict with the decision in Subhash Chandra Marwa. Subhash Chandra Marwa deals with the right to be appointed from the select list, whereas K. Manjusri deals with the right to be placed in the select list. The two cases therefore deal with altogether different issues. Recruiting bodies subject to the extant rules may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the objects sought to be achieved. Extant rules having statutory force are binding on the recruiting body, both in terms of procedure and eligibility. However, where the rules are non-existent or silent, administrative instructions may fill in the gaps. Placement in the select list gives no indefeasible right to appointment. The state or its instrumentality, for bona fide reasons, may choose not to fill up the vacancies. However, if vacancies exist, the state or its instrumentality cannot arbitrarily deny appointment to a person within the zone of consideration in the select list, where the appeals be placed before the appropriate bench for decision in terms of the answers rendered above, after obtaining administrative directions from one of the two houses. Thank you very much for your attention.